Alexandra works at Cunningham Swan here in Kingston and came just about the same time I did in 2020. I came in September and you came in December.
Yeah.
So I beat you.
Yeah, a couple months. We both had the right idea though.
Yeah, that's right. From practicing law in Oakville and Toronto. A Queen's grad in 2020. You might applaud or you might boo, whichever is your preference.
Hopefully it's a clap, yeah.
You know, some of us didn't go to Queen's, but that's all right. And they grew up in Vancouver?
Yeah.
Coquitlam?
Yeah.
Nice. So other BC people will love and support the Vancouverites. And Anthony, you will have seen her husband Anthony kicking around with some of our wee ones on Sunday morning also. And he's a police officer now, detective here in Kingston. Became a detective a year or two ago?
Year or so.
Yeah. So that's exciting. So we welcome you. We're grateful that you're here bright and early. I'm surprised all the kids aren't here with you.
Yes, yeah. I thought I wanted to concentrate, so we'll let them join later.
Perfect.
Yeah.
So this conversation is intended to be informative, educational, but also casual. If you have questions after this time for Alexandra, please feel free. And know that you can utilize her services from a legal perspective, but there's also no pressure. You don't need to sign up after this.
Yes. Yeah.
All right, welcome.
Thank you.
Yours.
Yes, thank you, Michelle. Can everyone see me if I sit, or would you like me to stand? What's easier?
Sitting is good.
Sitting? Okay. So I'll sit if everyone can see me. So as Michelle said, this is very much intended to be educational. I'd like for you to get something out of this. So if anything I say is not clear, or if you have an immediate question about something I've said, please just put up your hand, because I would like you to get this. I don't want to say something and then you don't understand, and then the next 9 points I make also don't make sense. So if something isn't clear kind of as I'm speaking, don't be afraid to put up your hand. I will stick around after, so if you do kind of have a question about your own personal situation, but maybe don't want to discuss that with the group, I will stick around after as well, and I'm going to church today too. So maybe speak with me after, but we will have an opportunity for Q&A at the end here. And this is very much information. Obviously, everyone's situation is specific, so it is very good to speak with a lawyer, with myself or with your own lawyer, about kind of what's right for your situation. So I do have a little handout here, and there are more available if you'd like to pick one up for a loved one or for someone else after. Feel free to take it. But I'm going to talk kind of at a high level about estate planning in Ontario. So the first thing I always start with, point one here, is about powers of attorney. So certainly we're going to talk about wills. I get a lot of people who call me up, Alexandra, I need a will. That's very true, but you also critically need powers of attorney. So what are powers of attorney? Powers of attorney are documents which allow another person or persons to make decisions on your behalf during your lifetime. Powers of attorney are particularly important in case you suffer a medical emergency, such as a stroke or a heart attack, and you lose mental capacity. You're no longer able to do certain things for yourself. In Ontario, we've divided it into two categories: a power of attorney for personal care, which covers anything affecting the body, healthcare decisions, where do you live, what do you eat, that sort of thing, and property or financial decisions. So who pays your taxes, who can deal with your home, who can deal with your money. One important distinction that I think is really important to say is a lot of people think the word attorney means lawyer. No, you do not have to appoint your lawyer. You do not need to appoint a lawyer in the family as your attorney. So in this context, attorney means legal representative. So a lot of people say, I'm power of attorney for my mom, or I'm power of attorney for my aunt. That's not quite accurate. What they are is they're actually appointed as the attorney. So they are either the attorney for property or the attorney for personal care. And it's actually the document itself, or rather the powers given under the document itself, that is the POA. So when I refer to power of attorney or POA, I actually mean the written document. And in our nomenclature, the person giving or making the power of attorney is called the grantor. So it is really important to have these two distinct documents. So when people come and see me, typically they leave with 3 documents. They leave with a will, they leave with a power of attorney for personal care, and they leave with a power of attorney for property. You can name the same people under both. So for example, if you do have a spouse, and if you lose mental capacity, you'd like for your spouse to be able to make decisions for you, it is absolutely 100% okay to put your spouse number 1, POA for property, and spouse number 1 on the power of attorney for personal care. However, you know, depending on your situation, you might want to appoint different people, and that's also part of the reason why we have separated them into 2 different categories. So for example, if you have maybe a son or something who's a doctor, or a daughter or a daughter-in-law who's a nurse, she might be a great choice on the personal care side of things, just given her expertise. But if you have someone in the family who's quite good at financial management or taxes, or maybe is a lawyer or something like that, that may be appropriate to appoint on the power of attorney for property. These people do need to work together, so there is some overlap. They're not kind of totally separate spheres. One area where there's overlap is where you live. So technically where you live is a personal care decision. It does fall under the power of attorney for personal care, but obviously how you pay for that is a monetary decision. I mean, what can you afford? Can you afford to stay at home with nursing care? Do you need to move into assisted living? Are you able to move into private assisted living, or do you need to maybe move into a provincially funded long-term care home? That sort of thing. So if you are going to appoint different people under these documents, just be mindful of that they will need to work together on certain occasions. Power of attorney for property, and it's important to remember this, unless you put a specific clause in there, it is effective immediately, which means that it can be used even if you are still mentally capable. And a lot of people say, well, why the heck would I ever want that? Gee, that's scary. I don't want that used if I'm mentally capable. The reason why you actually might want it used when you're mentally capable is if you are physically ill. So if you are bedbound, or if you cannot physically get to the doctor, the realtor, the bank, you know, to meet with your accountant anymore, we can do a lot of things online now, but we can't always do everything online. It may be really convenient to have a loved one start to be able to help you, even though you're mentally fine, but if you're physically weak. So for that reason, we do generally make the power of attorney for property effective immediately, but typically, frankly, it's often not used until someone has lost the ability to manage their property for themselves. Personal care, on the other hand, technically only becomes effective and can only be used if you are no longer mentally capable of making personal care decisions for yourself. And that makes sense, because even if you're bedbound, as long as you can tell your doctor, I want this, I want that, your doctor will still take instructions from you. So there's a slight difference about when they're effective. But the point is, if they're well drafted, both of them continue to be effective if you do become mentally incapable. You can put wishes in there. So if you do have really specific wishes, maybe about end of life, do you want to stay at home? Do you not want to stay at home? Do you have any particular procedures that you're really opposed to, or ones that you would like to be permitted? You can put instructions in there. So it's kind of like you can do a separate letter of wishes, or you can incorporate that right in there. So a lot of people ask me about a living will. A living will is a bit of a misnomer, because a living will technically refers to directions or instructions you've given to your attorney, typically in the document itself. So I do have a lot of clients include, it's sometimes called a no heroic measures clause, or a no hope clause, but basically it says, look, if I have a terminal condition and I'm dying, I'm just being kept alive artificially, you know, by this ventilator, by whatever this is, at that point I'd like that turned off, and I'd like to be allowed to die naturally. So that's something that is important to a lot of people, and that's something you can put right in that document yourself, but again, you don't have to. So if you'd prefer to have this conversation with the person you're naming directly, you can do that as well. Orally or in writing, it is important to consider this. One thing to note is that your attorney does not have to act. You cannot force someone to be your attorney. You cannot force someone to be your executor. So please, please, please have a conversation with the people you are thinking about naming to make sure, A, they're willing and able to do it, and because B, I guess the second point is, if they're not, or if they're like, gosh, that's a big ask, I don't know if I'm going to have the time, I don't know if I have the knowledge to do that, you want to be able to change these documents while you're still capable. So for example, if you don't tell someone that they've been named, they may not even know to contact your lawyer and to start to help you out. So speak with the people you're thinking about naming. If you're going to, I always encourage clients to appoint at least kind of maybe one primary person and one alternate. So for example, again, go back to spouses. If you do have a spouse, it's great to name your spouse number one, but you got to have a backup, because what if you're both injured? Or what if one of you dies and the other becomes incapable? So it's really, frankly, not great just to have, husband and wife appoint each other with no substitute or no alternate, because that's not very helpful if something has happened to one of the spouses and maybe the other can't act for whatever reason. Yeah.
Is there a hierarchy for that?
You decide. So the point is, you decide the hierarchy. So you can appoint a particular person number one, and you can appoint another person or persons as number two.
It's not a legal hierarchy?
No, well, I'll talk about that. Yeah, I'll talk about that next. So there's no legal hierarchy. So the point is, in Ontario, you can decide who you want to be your primary number one attorney, and then you can decide who you want to be the alternate if the primary can't or won't act. If you did want to appoint more than one person, you can also do that. So there's the option to appoint people jointly, which means if they make a decision, they have to make a joint decision that they all agree on. That can be a little bit tricky. I kind of joke that it's tough enough to get 2 or 3 people to agree on where to go for lunch, so it can be even more difficult when we're talking about major decisions like, do we sell mom's home? Where does mom move? So these are not easy conversations. So if you are going to appoint 2 or more people to act jointly, or even 2 or more people to act jointly and severally, which means they can act together or they can act individually, either way, it's really critically important that they kind of know each other, that they can work together, because a lot of the disputes we see is when attorneys don't get along. And so this maybe is between children. If there is some tension among your children, maybe you don't appoint all of your children, or maybe you look at different options. So just one thing to discover. I always relay this conversation, but I had one woman come in, and like me, she had 3 children. And she said, kind of before we even got into anything, she said, Alexandra, I have 3 children, and I want all 3 of them to be equal beneficiaries, and all 3 of them to be executors, and all 3 of them to be attorneys under the POA documents. And I said, okay, let's break this down. So equal beneficiaries, no problem. When you die, it goes 3 ways, great. I don't think anyone has a problem with that. That's pretty plain vanilla, good. Executors, okay, well, let's talk about that. But we ended up talking about the powers of attorney first. So it turns out one of her daughters is deathly afraid of hospitals and needles, like to the point will pass out on the floor at the sight of blood. So we kind of laughed about it. So I'm like, that's great. You're in hospital, you're lying on the stretcher. The doctor's like, what do we do? Well, and they're having to resuscitate your poor daughter on the floor. I'm like, do not make this poor girl have to make these decisions. She's obviously not going to be good at it. And the thing is, you can love your children. They can be wonderful people, and they can be absolutely the wrong choice for certain things. So we laughed about it, and we did ultimately decide to appoint the other children, because the fact is, the daughter who's not named, there's still a positive obligation to consult with her, so she's still going to be consulted with, but she's not there on the spot. Someone who's deathly afraid of hospitals is not there on the spot being, badgered by a doctor about what do we do with mom. So again, think critically about who you're naming, and if you're going to appoint 2 or more people, think really critically about whether or not they work together. This is kind of leading to your question. What happens if you don't have powers of attorney in place? If you do not have powers of attorney in place, a family member, a spouse, or a child often has to apply for something called guardianship. You do not want guardianship. It is $10,000, $15,000 at least to do. Powers of attorney are maybe by themselves a few $100s to do. So they're kind of relatively cheap documents, especially when you're thinking about the fact this is while you're still alive. So very critically, no one, not even a spouse, has an automatic right to manage your property. I'll repeat that. If you do not have a continuing power of attorney for property in place, no one, not even your spouse, has an automatic right to manage your property. So if you are married or if you are in a common law relationship and you want your spouse to be able to make these decisions, it is critically important to have a power of attorney for property. So we have seen situations where a wife or a husband has had to go to court to get permission to manage their wife or husband's affairs. Not a situation you want to be in. Yeah.
Unless it's jointly owned?
No, this is the thing. You don't get around it by joint ownership. No. Joint ownership, the only thing that means is if one of you dies, the other gets it 100% beneficially. Or sometimes with bank accounts, one of you dies, the other can access it. But it doesn't get around. So let's say you own your home 50-50. Yeah. that doesn't give you a right to sign over your husband's 50% in the home. So let's say you want to sell the home. So let's use my example, Anthony. So Anthony becomes incapable. I can sell my 50%. Unless Anthony has given me power of attorney, I can't sell Anthony's 50%. I don't know about you, most people don't want to buy 50% of a home. They want to buy 100% of a home. So no, joint ownership doesn't get around it. And same thing, there's a lot of things that necessarily are not joint. Your tax-free savings account, your RRSP, your RIF, your pension, those aren't joint. Those are individual to you. And also critically, you can't necessarily file taxes and stuff for your spouse. So power of attorney for property is critically important because no, joint ownership doesn't get around it. You don't necessarily have the ability to step into your spouse's shoes and deal with their property interests. Now, there is a hierarchy for under the Health Care Consent Act. So it's not as broad as the power of attorney for personal care documents I do. So the power of attorney for personal care documents I do really cover any personal care decision. Now, if you suddenly have a stroke or a heart attack and you don't have powers of attorney for personal care, there is a list of people who can make a limited range of almost like emergency decisions for you. Yes, do we do surgery? No, do we not do surgery? So kind of like immediate decisions. So in that hierarchy, yes, it is spouse number one, but then it goes to kids. So let's say, what if you're estranged from one of your children? That kid has a right to make decisions for you. We're not kicking that kid out, right? So, or it's not very practical maybe if your children are in the US or abroad or not local, right? They can't come here, they can't give instructions. So the point is, do these documents because it's critically important that you have the people you need in place to make these decisions for you. So I do like to start about that. I know we're going to talk about wills in a sec, but I think the powers of attorney are really undervalued. A lot of people don't know they need them, but even if you're married, you do actually need powers of attorney in place because if we're dealing with an emergency situation, I have to say, I'm sorry, I'm referring you to my colleague in litigation, and by the way, this is going to be a minimum of $10,000 to $15,000. That's not what we charge, that's what almost everyone charges because the stack of documents you have to present to the judge is about this high. You have to do a management plan, you have to talk to the public guardian and trustee, and it can also be weeks before someone is actually appointed to make these decisions for you. So definitely do powers of attorney as part of your estate plan. Yeah.
If you're in a situation where you have a previous marriage and you're living common law with somebody, does the previous spouse then get in there?
Possibly, yes. Yeah, so if you separate or you divorce, it may not have the impact on your estate planning that you think it does. So they've just introduced, it's not actually fully enacted yet, that if people are kind of formally separated or divorced, they can be edited out, but that doesn't help someone who's kind of recently separated or maybe has a new partner or this or that. So no, the point is if you've had any sort of relationship change, like a positive one, you've just gotten remarried or you've just entered into what we call like a conjugal relationship with someone, you're living together with someone, so you've entered a common law relationship, you've gotten remarried, or conversely, you've separated or divorced, you have to update these documents. Because if it's a recent separation, yes, your ex might be the one entitled to make these decisions. Are they going to act in your best interest? How amicable was the divorce? You know, like, I don't know. So the scary thing is, yeah, exactly, change it. Now, it used to be legal marriage revoked a will. That was actually a rule. It used to shock people, but legal marriage revoked a will. They've since rescinded that. But if you did get married, really kind of any time until I think it was 2022, if you did a will before then and then you got married after, it may not be valid. You may not have a will. So again, the law is weird in terms of what happens when you get married, separated, divorced. So the point is any relationship change, see a lawyer because you may have to update your will and your powers of attorney. So I'll read this to you because I think it's really important to hear. All adults should have a will, even if a person has not yet acquired significant property. There's no bad luck in having a will, and I find most of my clients feel relieved after signing their wills, knowing that they have appropriate plans in place. So I always tell this story, but I once did one of these seminars, and a gentleman came up to me after, and I think, you know, there's a lot of cultural kind of hang-ups about doing this and that, and that's fine. I get it. This isn't a fun thing to think about. But he said to me, and I quote, "Alexandra, if I make a will, I'm going to die." Think about that. If I make a will, I'm going to die. So I looked it up and I said, "You're going to die, make a will." Like, You are not magically preventing your death by not seeing me and doing a will. Like, there's no connection. But I know, like, there's a hang-up, right? If I think about it, something bad's going to happen, right? So no, the point is you are going to die. Hopefully you'll never become incapable, but you are definitely going to die. So have a plan in place. You're really doing a favor to your loved ones. You're not going to benefit from it. No, I mean, necessarily, you will not benefit from this, but don't leave a mess for your spouse, for your family, for other people. Because, and this leads into number 4, what happens when you don't have a will? Your property is distributed according to the rules of intestacy. So the rules of intestacy, to be honest, haven't been updated in about 300 years. I'm not kidding. I'm not kidding. They exclude common law spouses. You die without a will, your common law spouse at 30 years gets nothing. Gets nothing. They exclude stepkids. Stepkids are not considered to be children. They've got to be biological children or legally adopted. It excludes charities, including the church. So if you are intending to leave something to the church, but you don't have a will, too bad, so sad, nothing is going to the church or any other charity that means something to you. Also excluded are friends and any other non-blood relatives. So it is an old, rigid chart, and it's not perfect. Non-blood relatives. Non-blood relatives, yeah. Brunettes can still inherit, but yeah, but non-blood. So if you are planning to do even anything to grandchildren, like if you're hoping to maybe skip your children, go to grandchildren, not happening. Like it's rigid. So I have seen very sad cases where common law spouses are actually having to sue their late spouse's estate to get really that to which they're entitled. Because under the law, again, common law spouses get nothing. So, and that's not what you want to be. You're grieving, you've just lost your partner of 30 years, and you're having to sue them to get really what you probably could have gotten so easily if they just had a will. So do a will, because again, if you do plan on giving any planned giving to the church or to anyone else or to friends or to grandchildren, it's really, really important that you put this in a will, because if you don't put it in a will, it's probably not going where you would have wanted. Number 5, we actually already touched on. Any significant relationship change, update your will, update your powers of attorney. Now, a lot of us do want to provide for children or grandchildren. It's important to know, and I think many of us do know this, that children under 18 don't have full legal rights and they can't receive property directly. So if you are planning to benefit grandchildren, or in my case, children, you have to put a trust in the will. And the cool thing about including a trust in the will is we can put a later age. So I don't know about you, but I wasn't particularly wise with property at 18. So it's probably better to say, hey, maybe until I'm 25, maybe until I'm 30, the money is managed for me. I'm kind of maybe given what I need or given money for school, that sort of thing. And then magically, once I'm more mature, grown up, able to do it, I get the money at 25, I get the money at 30. So that's the cool thing, again, about doing a will is we can put in conditions. If you have anyone who is disabled, and by that I mean it can be mental or physical, but if they're receiving Ontario disability support, it is critically important to put a special kind of trust in your will for that person, because if you don't put the appropriate kind of trust in place, they will be kicked off ODSP, or they'll be put in the awful position of having to decide between ODSP and their inheritance. So, yeah.
Do you have to appoint a trustee?
Yes, yeah. So that's the component. If you're going to do a trust, you need to appoint a trustee or someone to manage it. This can be the same as your executor, and it often is. Okay. Yeah.
Alexandra, just going back to power of attorney, we have often seen situations that we did it at 50, made our will, thought, took care of our children.
Exactly.
But that power of attorney is now incompetent.
Yeah. Oh, it's scary.
Keep it up.
Yeah. Absolutely, yeah. So that's the risk with doing someone older or doing an age mate is, gee, are they going to run into the same sort of health issues that I'm going to run into? So that's why you got to keep these current. So, I mean, we say when you sign it, it says, this is my last will and testament. It's not your last will. You'll probably have 3 or 4 wills in your lifetime. You'll probably have 3 or 4 sets of powers of attorney, and they absolutely should be updated because we've seen this. My colleague, and he was wealthy, like it didn't make sense to me, but a very wealthy gentleman hadn't updated his will since 1971. His executors were all dead. All but one beneficiary was dead. He hadn't done an affidavit of execution, which is a witness affidavit, and everyone who knew him was dead. So trying to get someone to say, yep, this is this guy's signature was very difficult. So it took about 6 months just to find someone able to do this and track down the beneficiary. That beneficiary was happy because they got everything. But it was almost like the guy didn't have a will. And we've actually seen that, where if everyone you've named is dead or, disabled, is that what was the point, right? So keep this current, absolutely. If people do become sick, they don't have the time, they move away. So for example, again, you can love your children equally, but if one of them lives in Vancouver, how practical is it to have them? Another example, and I'll just give you a heads up, but if any of your kids are in the US, you need to think about very hard about appointing them. Not now you say they're Canadian citizens, doesn't matter. If they're US persons or US residents or non-residents of Canada for tax purposes, it can cause a mess up on this end. Okay? So any kids in the US, again, you can love them, you can make them equal beneficiaries when you die, but just think long and hard and talk with a lawyer, talk with your accountant before actually putting them in charge of anything. So yeah, so it's very important to do trusts. And if you're parent of a minor child, so in my case, it is important to designate someone you'd like to physically look after the children, to kind of step in your shoes, and look after the kids. There are certain things you can do on death, or before death actually, to help save estate administration tax or probate tax. So certain assets, this is number 7 if you're following, on certain assets, including but not limited to RRSPs or RIFs, life insurance policies, tax-free savings accounts, and some pensions, you can designate a person or persons as your beneficiary. So if you are married, it is critically important to do this. I find banks, for some reason, especially if you're just at the branch level, are not always good about telling people hey, you set up a tax-free savings account. Did you know you can designate your spouse to receive this? There are some really cool tax things we can do, especially if you're designating a spouse, because a spouse on many of these things can almost be like super beneficiary, they can get it and it's very tax advantageous, especially if you're rolling over something like an RRSP or a RIF. So the default beneficiary on all of these things, unless you sign paperwork to the contrary, the default beneficiary, even if you're married, generally is your estate. Now that can be fine in some circumstances. Maybe people don't have a spouse or don't have kids. Leaving it to your estate could be fine. But another cool thing is you can also designate a charity. So I've had some people designate charities as beneficiaries on their life insurance policies, or charities like IRMAC on their TFSAs or other assets. So the point is, when you're reviewing your will, you should also review these special kind of assets as well: life insurance policies, pensions, or what we call registered accounts, TFSAs, RRSPs, LIFs, LIRAs, that sort of thing, to see if you should designate a beneficiary or beneficiaries on them. Because the cool thing is, generally it kind of just goes right to that beneficiary, but there are some tax implications to your estate that are important to review with a lawyer, with your financial advisor. Another common way, we talked about this briefly, joint ownership. Another common way for people, especially for couples, to try and reduce estate administration tax is to own assets jointly with the right of survivorship with another person. So for example, a lot of couples, including Anthony and I, co-own their home as joint tenants. So what that means is if one of the spouses dies, the other automatically becomes 100% beneficial owner. Now you do still need to register something called a survivorship application, just to take the deceased spouse off of title and to update the property tax bill as well. But at least kind of beneficially it goes 100% to the spouse. There's no debate about who it is. You can often do this with joint, with bank accounts as well. Make both of you joint. One of you dies, the other gets it. So it is very often very appropriate between spouses. But again, second marriages, third marriages, it may not be so appropriate. So if you don't necessarily want everything going to your second or third spouse, or if there's a blended family situation, you do need to talk to your lawyer about what's most appropriate there. I will caution you, because I get a lot of widows and widowers come in and they panic, right? They've just had a devastating loss. They've just lost their spouse, often of many years, and someone has freaked them out about probate. So they come in and they said, Alexandra, I'm not even really sure if I need a will, because you know what? I just threw my 3 kids on everything. My 3 kids are now in the house. My 3 kids are now on this. My 3 kids are now on that. You may have just caused a tax nightmare. So whatever you saved in probate tax, you may have just cost yourself a million times plus in income tax. So you may have affected your principal residence exemption from income tax on your home. You may have caused an extra tax return you have to do each year because you've created a trust. It's a bare trust to your beneficiary during your lifetime. Those people now have to file tax returns every year. Plus, what if one of your kids gets divorced or separated? I have seen situations where mom's bank account is being attacked by daughter-in-law. So the joke is, in-laws can become outlaws.
Yeah.
So we're seeing, everyone knows it's mom's bank account. It's not really the son's, but the son's on there. So it's getting dragged into son's horrible divorce, and mom is at risk. The other sad thing, and I've seen this too, is what if one of the people you add suddenly has to go into bankruptcy or insolvency? Again, your asset can get attacked. So a lot of people panic. Probate is not the end of the world. There is sometimes a benefit to being able to say, is this mom's? Is this mine? Because we've had situations too where you've added one kid. Maybe, again, you have 3 kids, you've added one of the kids, and, mom dies, and the kid's like, well, guess what? This is mine, and I don't have to share with you two. Ha, 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 ha. So not surprisingly, that leads to estate litigation too. So I think before you do anything, it's really important to say, what's your intention here? And again, paying a little bit of probate tax is not the end of the world. It is a very organized kind of regime. Yes, it's a little bit of tax, but it may actually be easier just to leave things just in your name. And then there's no debate about, is this mom's, is this someone else's, that sort of thing. So again, talk to your lawyer before just kind of throwing someone on jointly on another asset.
A quick insert.
Yeah.
It's only 1% or 1.5% talking about with probates.
At its worst, yeah.
At its worst, it's 1.5%, so
Yeah.
it's not a big deal.
Yeah.
The other thing is, and it's too complicated here, is two wills. One that's
Yeah.
where things are in one.
Yeah.
You're coming.
That's my next point.
Oh, you're
So yeah, actually, so you don't need to pay probate tax on everything because you don't need probate for everything. So just to take a step back, probate is basically proof of the will. It is proof that this is the last will, and that most critically, the people appointed as executors are entitled to administer your estate. So you don't actually need probate, very importantly, to deal with shares in a privately held business corporation. So if you have your own company, maybe it's just a holding company, but maybe you're an incorporated professional like a doctor, accountant, a lawyer, anything. If you have just shares in the family company, your executor does not need probate in order to be able to deal with those shares. And that's just under the Ontario Business Corporations Act. So almost all of my business owner clients do 2 wills. They basically kind of do a will for their corporate assets and their will for everything else. The other thing you don't typically need probate for currently is automobiles. You don't generally need probate to transfer automobiles. So I've had clients with big car collections. We're doing a second will for that. Jewelry, artwork, especially if it's being kept in the family. Now, if you do have like a group of 7 painting or a really valuable painting, we may have to probate that just for provenance, kind of to help prove, the chain of ownership, but not always. And again, if a lot of family artwork jewelry is being kept just amongst your kids or grandkids, we don't generally need probate to transfer it. The other thing, and this is quite common in Kingston and area, is if you bought your home under registry, that was the old paper system of land ownership. If you bought your home under registry, we actually may not need, depending on the situation, we may not need probate to sell or transfer your home. So all of Kingston is now in land titles. So the rule is if you bought under land titles, which generally in the township area is kind of post 2007. In the city, it's post 1997. So if you bought kind of in the old city of Kingston after 1997, if you bought in old Kingston Township, so West End elsewhere, after 2007, you're probably under land titles. So under land titles, we do need proof when the last sole owner of real estate dies. We typically do need probate to transfer to anyone, to transfer to kids, to transfer to a third party or whatever. But if you did buy your home kind of 20, 25 years ago, have your lawyer check if you qualify. It's called a first dealing since conversion. But if you've owned your home for a long time, if it's your kids or anyone, may actually be able to sell your home without probate. So for a lot of my clients who've owned kind of 20, 30, 40 years, again, I'm actually doing 2 wills for them. And I'm actually putting their home, which is often their most significant asset, under a second will which doesn't need probate. So it's slightly more sophisticated, but talk to your lawyer about it. It's doing 2 wills. So the CRA has said a person can have only 1 estate for income tax purposes. So it does not cause an income tax problem to have 2 wills. It's purely to save probate tax, estate administration tax, probate tax. So it's kind of a cool planning technique, and I'm increasingly talking to people because, when your home was worth, $100,000, maybe it wasn't worth it. But now, so much of it, the real estate's just gone insane. Most of us, our homes are worth, $500,000, $600,000 or more. So since real estate has become so much more valuable, it's good to do this planning. Again, you won't benefit from it, but I can tell you your kids will be really happy when they've saved all this money after you've passed away. The last point I want to leave you with, because I do want to leave time for questions, is estate planning is dynamic. We kind of talked about this a little bit. Your situation will change over time. So the powers of attorney and will that you should have when you're in 20s and single are not the same ones that you should have when you're in your 40s or 50s and married with young children, or if you're in your 70s and 80s and retired. Your powers of attorney and your will should be updated to take into account developments in your life. If loved ones pass away, significant relationships begin or end, new family members are born, loved ones become disabled, or your assets or your obligations change, absolutely update your estate plan to take this into account. So that's kind of very high level, but I did want to leave time for questions if anyone has any questions for me. I've thrown a lot at you. Take this with you, please, and share it and kind of think about it. There's some extra ones on the way out, yeah, if you wanted to pick it up. Does anyone have any kind of particular questions? Yeah.
Alexandra, I've just been over the years caregiver for people. And I just want to give a scenario of the funeral home situation.
Yeah.
Someone with a will and power of attorneys, you go to the funeral reception afterwards, and everyone they're sad, but they're happy because he's left everything in order. And the next client has, oh, I'm not going to die, hasn't a will, hasn't anything. And the bickering and the sadness and the unrest is just incredible. You could just feel it in the room.
Yeah. We've seen disputes where we haven't even started talking about the money yet. It's a fight about should dad be buried or should dad be cremated?
Right.
And dad's sitting on ice until this is decided, or do we have a big celebration of life or just a small thing with family, So especially if you have kids, but even if you don't have kids, just do anyone who matters to you, friends, family, do them a favor by organizing this. And one cool thing is you can actually pre-plan your funeral. Now, a component of this is you can actually pre-plan and prepay. So that's a cool thing is you can kind of, pre-plan, set it all out. What do you want? Do you want cremation or burial? Because they'll help line it up with the cemetery as well. You can coordinate all of that. So cremation or burial, big service, small service. What songs do you want? What should we serve? You can line this in. You can lock in a lot of prices. You can't lock in everything. You can't lock in catering or what the government might charge to file things, but you can kind of lock in the price roughly, which is really cool. If you don't want to prepay or can't afford to prepay, you can also just pre-plan it. So you can go in and they will take down your wishes. So when the time comes, even if it hasn't been paid for yet, at least we know exactly she wanted these songs, she really wanted these hymns read, or these psalms were really meaningful to her. Do we want a church funeral, bring in the minister, that sort of thing. So you can kind of organize a lot of this and let people know. And again, if you think there's going to be a debate, maybe you prepay, you lock it in, and most importantly is tell people, because I don't want to think, John didn't plan anything. I go to funeral home A and it turns out there's all this stuff at funeral home B. Oh, great. Well, we already buried him. So and as a funeral director once said to me, you cannot uncremate a body. It's a one-way stop. You can always cremate later. Oh, Dad wanted cremation. Great. But you cannot uncremate a body. So, if you're thinking burial, speak up, because the trend, I would say, what I've heard, because I wasn't practicing then, 30 or 40 years ago is about 75 burial, 25 cremation. This is switched. I can tell you statistically, it's about 75 cremation, 25 burial now.
So more in a plot that way.
Yeah, exactly. Yeah. So really, whatever you want, speak up.
So all that planning is done with the funeral?
You can do that right with the funeral home. They will record it, and there's no obligation to pay. So if you want to lock in the price and lock it in, you can prepay, which is great, because that's obviously the first expenses any estate is the funeral and cremation and burial. So you can pre-plan and prepay, but they will also, if you're not sure you want to pay just yet, or maybe you can't afford to, although they often have monthly ones you can work with, is you can pre-plan. They'll record your wishes, they'll keep it on file, so when the time comes and the kids call that funeral home, they'll be like, I don't even know what Mom wanted. Did she want a church minister there? Did she not? Did she want this? At least they'll have a little sheet, kind of that your wishes at the time. Yeah.
The end of life planning, I think, is a great idea.
Yeah.
But it doesn't have any legal status, correct? It's just within the family, or does it?
You can put it right in the power of attorney for personal care document. So I have a lot of people, if they do not want to be kept alive artificially, like if they're brain dead and they're just being kept alive by a machine, a lot of them put it right in the document. And so the thing is, if your wishes are known to the attorney, your last wishes are known to the last, while capable, I should express that. So the last wishes you expressed while you were still capable, if your last wishes you expressed while you were capable are known to the attorney is generally required to comply with them. So even if the attorney maybe personally disagrees with it, they're required to comply with it. So no, you can put wishes right in the power of attorney for personal care document. And in that case, again, the attorney's generally required to comply with it. Or you can, like I said, a lot of people do have a separate document or just kind of a handwritten note they leave to their kids, kind of spelling out more specifically what they'd like. But if it is a separate document, it's not always as locked in. You're right, yeah. Yeah, okay. So it's usually just wishes. Don't try and do gifts or anything you want to be binding in a separate document. If you want something to be binding, put it in the document, either the POA or the will. Yeah.
But when you get ill, if you're mentally capable,
yeah,
you can do a do not resuscitate
exactly
document, which is then you have to post on your fridge.
Yeah.
Because we went through that with my late husband.
Yeah. So a DNR, the difference between a DNR and putting wishes in there is a DNR is usually situation specific. So if I'm going in for a heart procedure, they will walk through everything, they'll tell me everything that can go wrong, and they'll usually ask me, they'll be like, if this happens, what do you want? If this happens, what do you want? So I might put, look, if this is going sideways and I'm dying, just, don't, or I don't want CPR. So that's something usually that's like situation specific. I'm going into a high risk situation. I sign myself while I am capable. This is more of a global DNR. So typically it kicks in that someone's had the heart attack or the stroke. We've tried to save them, because they do have an obligation to try and save you. Tried to save them, it's become clear they're not going to get better. This is devastating. It's what would you want in that instance when you can't speak for yourself? That should maybe be in the document, is when you can no longer sign the DNR yourself. Yeah.
Have you heard about death dinners? You invite the family.
Yeah, living funerals.
Conversation's going to be done. Because young people, we're going to live forever.
Yeah.
Don't think
No.
that we're going to die ever. And we have to talk about it.
Yes, yeah. And one thing I've heard that sounds really, by all accounts, it's meaningful. It's sad, but it's meaningful, are living funerals, right? So this does often arise in medical assistance in dying. So if someone is pursuing MAID, used to be called physician-assisted suicide. It's now called medical assistance in dying. But those are among the few people among us, they know when they're going to die. They literally have a date, March 1st, whatever it is. So most of us we don't know our date. We don't know our expiry date. We've all got one, but it's on the back here, and we can't see it, right? So, but they know, right? So I've heard of some really meaningful where they've gotten together and the person's there and they can say I love you, and that is that chance to say that last I love you. How many of us get that, right? Mm-hmm. So I love the idea of kind of living wakes or living funerals and talking about this, and just again. I had a situation, it was so informative to me, is where a woman did have cancer, and on the early stage, she tried to tell her kids, look, my stuff's here, this and that, and they all went, la, 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 we can't, Mom, you're going to get better, da, 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 and they all literally went like that. And so she didn't get to say, and then she died, and we couldn't find anything. And she tried to tell, and they were kicking themselves, so we had to actually submit that she died without a will. They're pretty sure she did have a will, but because they couldn't find, lawyer's information or this, everything was a dead end, they thought maybe it was this guy. We wrote to a real estate lawyer, no, he hadn't done a will, this and that. We tried everywhere. So it depends on your family. You might have to try more than once, but not a bad idea, because the fact is, powers of attorney are for you. You're still alive. Like, these are the people you want making decisions for you while you're alive. Your will is really for your family and your friends, to not leave a mess when you die. It's the right people administering everything. It's going where you want it to go, whether it's the church, family, friends, whatever. And again, you can include instructions like, I want cremation, I want burial. I've set up everything at James Reed. Go to James Reed, give him a call, whatever, So, but yeah, having these conversations is good, because it's the ones where, like, Mom tried to tell us or Dad tried to tell us and we didn't listen or we didn't want to know, So leave an order to state for sure. Yeah. Pre-arrangement plan.
Here is called pre-arranged funeral plan.
Yeah.
So it's all done. But more than that, if I died internationally or died internationally, they will get the body back here.
Yeah, yeah.
It's all covered. It's
Yeah, there's an insurance product.
policy.
It's not. I think it's you can vary it. No, it's 800 I think often it's 500 kilometers. So it's not just you die, you know, in Florida, but you die in Vancouver, you die in Calgary, you know, they or Europe, you know, they can bring you back. So that is an insurance product you can buy if you do spend a lot of time, you know, in the U.S. or elsewhere, and you're worried about, gee, how do we get my body back?
Because that's a
Yeah.
killer for family.
Yeah.
Trying to get the body.
Oh my God. No, I had this. I had a lady, her husband, they were on it was so sad. They were on the trip of a lifetime to India. And he died over there, massive heart attack, died. And I don't mean this like to sound racist, but the proof of death certificate was like a 3-year-old had done it. Like it was almost in crayon. And I'm like, I can't take this to, like, they're not going to believe you died. Like it was so unofficial looking. And like, that's all she got. And then because it was so unofficial looking, quite frankly, we had to deal with like the Indian consulate to say like, yes, this is legitimate. We had to get a translation. And so like, it wasn't just like one simple document. My husband's died, you know, please give this to me. It was and then getting them back, like, you know, she had to like call Air Canada and it's a special thing. And like, it was just, I mean, it was awful. It was awful. So just hearing her experience was like, oh my God, that's terrifying.
This is wonderful
9:15, yes.
But,
And on a bummer note, but yes, sorry.
for the sake of getting ready for church, and
Yes.
we must close it off.
Yeah,
now.
yeah. And I think we're going to have a second component of this. I think Michelle mentioned,
Very glad to hear
yeah,
that.
date TBD, but I think there might be a financial advisor or someone else here to kind of talk maybe more about plan giving.
What I thought I understood about this subject, I realized how much I do not understand and how much I need lawyers' advice.
Yeah.
So very interesting, and I want to, on behalf of this group here, to thank you very much for your wonderful presentation. And
Thank
we
you.
look forward to the second opportunity.
Absolutely.
That date has not been set, I understand, but
Yeah.
keep tuned.
Absolutely.
So thank you very much.
Yeah.
again.
Thank you for your interest.